Most people think whatever is written in their lease is set in stone. You sign the paper, you initial next to 20 different paragraphs, and you assume that if things go wrong, that document dictates your entire life. If you get 2 weeks behind on rent, or if a dispute breaks out over a maintenance issue, you might assume your landlord holds all the cards. You might assume that because it's their building, their property, and their name on the deed, they can simply step in, change the locks, cut off your power, and tell you to get out. Except that is completely, fundamentally wrong. If your landlord crosses one specific legal line, the law doesn't just protect you. In almost every single state, it actually turns the tables and requires them to pay you thousands of dollars in cash penalties. There is one specific legal term that explains almost every single situation we are going to cover today: self-help eviction. Self-help is the official legal term for a landlord attempting to kick you out, force your hand, or make your living situation so unbearable that you leave on your own, all without ever setting foot inside a courtroom, swapping out your deadbolt while you're at work, shutting off your power, gas, or water in the middle of a winter payment dispute, removing your front door off its hinges under the excuse of maintenance, dumping your clothes, electronics, and personal belongings out on the curb. Every single one of those actions is flat out illegal in all 50 states. It doesn't matter how many months of rent you owe. It doesn't matter what outrageous clause is buried on page 14 of your lease agreement. And it doesn't matter if your landlord genuinely, passionately believes they are doing the right thing. None of that grants them permission to bypass the judicial system. Here is the fundamental rule that every tenant needs to memorize. A landlord has exactly one legal path to remove a tenant from a rental unit. First, they must issue a formal written notice that complies with statutory timelines. Second, if you do not comply, they must file a legal complaint in court. Third, they must attend a formal hearing where both sides present evidence. Fourth, they must receive an official judicial judgment or writ of possession. And fifth, only an authorized officer of the law, such as a sheriff or marshal, is legally permitted to physically enforce that eviction order. That is it. There is no shortcut. There is no emergency loop. There is no special exception, because a landlord is angry, stressed, or losing money. Anything outside of that exact 5-step sequence isn't just frowned upon by the courts. It is an illegal act, carrying severe financial liabilities. The tragic reality is that the vast majority of tenants who experience these violations never collect a single penny of what they are legally owed. They get panicky, they get stressed out, they sleep on a friend's couch for a week, pay hundreds of dollars out of pocket for an emergency hotel, and quietly move on with their lives. They absorb the financial hit because they assume the landlord was allowed to do it. Those self-help eviction laws were written specifically to punish landlords for stepping outside the court system. The money is sitting there waiting to be collected, but only if you know how the legal mechanics work. Let's talk numbers, because these payouts add up insanely fast. When you take a landlord to court, or bring a claim to a housing board for an illegal lockout or utility shutoff, your financial recovery gets divided into 3 distinct buckets: actual damages, statutory damages, and attorney's fees. Actual damages cover the direct, out-of-pocket money you lost, specifically because of the landlord's illegal action. This includes the emergency hotel stay you had to book because you couldn't access your bedroom, the cost of eating out at restaurants because your power or gas was cut off, lost wages from missing work to deal with the lock dispute or attend emergency court hearings, and spoiled food in your refrigerator after a deliberate power shutoff. Statutory damages are where the numbers get really interesting. Statutory damages are flat-rate penalties written directly into state law specifically to punish the landlord, regardless of whether you spent money on a hotel or not. The court awards you this money purely because the landlord broke the statute. For example, say your rent is $1,500 a month. You come home from work, key in the door, and the lock won't turn. Your landlord swapped the deadbolt without a court order. In Texas, that specific illegal lockout entitles you to 1 full month's rent plus a $1,000 statutory penalty. That's $2,500 owed to you automatically, before you even count actual damages like hotel bills or lost work wages. In California, state law imposes statutory penalties of up to $100 for every single day you are locked out, stacked right on top of whatever emergency hotel rooms or food costs you had to pay out of pocket. In states like Massachusetts or New York, courts frequently award treble damages. That means if an illegal lockout costs you $2,000 in emergency stays and storage fees, a judge can automatically multiply that by 3, handing you a $6,000 judgment against your landlord. On top of all that, under almost all state self-help eviction statutes, if the tenant wins the case, the court orders the landlord to pay 100% of the tenant's legal fees and filing costs. This means tenant rights attorneys will often take these cases with zero upfront fees because they know the landlord is legally obligated to foot the bill upon judgment. Now look at how two different tenants handle the exact same situation. Tenant A gets locked out. He panics, calls the landlord, gets ignored, and spends $300 on a hotel. He gets furious, screams into his phone, and eventually gives up, finds a new apartment, and moves out. He's out $300, stressed to the bone, and the landlord gets away with it scot-free. Tenant B gets locked out. She stays completely calm. She pulls out her phone, shoots a quick video showing her key failing in the new lock, logs the time and date, and sends a quick text to the landlord asking why the locks were changed. When the landlord admits to changing them, she saves that text, calls the local non-emergency police line to get an official incident report, and files an emergency order with a local housing court. Same lockout, same landlord. But tenant B walks away with $2,500 in statutory cash, her legal fees covered, and her apartment back. The exact same contrast plays out with utility shutoffs. If your landlord cuts off your heat or water over a late payment, calling a local plumber to fix it yourself, and quietly resenting your landlord gets you nowhere. Taking time-stamped photos, calling the utility company to confirm the bill was paid on your end, and serving your landlord with a written demand citing state codes creates the exact paper trail required to collect statutory damages. Two tenants, same exact landlord behavior, night and day financial outcomes, all because one knew what the violation was worth and documented it immediately. Here's the specific psychological trap that catches almost everyone: lease clauses. A massive number of standard leases contain lines like, "Landlord reserves the right to re-enter premises and repossess property upon non-payment," or "Landlord may terminate utility service for breach of contract." Tenants read those lines and think, "Well, I signed the paper. I guess I waived my rights." No, you didn't. In almost every state, clauses like that are entirely void and legally unenforceable. You cannot contract out of state law. A lease is a private agreement. It cannot grant a landlord special permissions that violate state statutes. A lease can grant you more protections than state law requires, but it can never strip away the baseline protections your state guarantees. If a sentence in your lease claims your landlord can lock you out or cut your water, that specific sentence is legally worthless, even though the rest of the contract remains active. Most tenants treat every single line of a signed lease as equally binding, almost as if the document creates the law on its own. It doesn't. State statute always overrules private paperwork. Quick heads up, if you're dealing with a nightmare rental situation, make sure you're subscribed. We're breaking down a lot more hidden tenant rights in this series. Now, there's a second protection that stacks directly on top of everything we just covered: retaliation protection. If your landlord hits you with a sudden eviction notice, spikes your rent drastically, or refuses to renew your lease shortly after you assert a legal right, like reporting a code violation to the city, the law in most states creates an automatic legal presumption that the landlord is retaliating against you. This flips the legal burden of proof entirely. Normally, if you sue someone in court, you have to prove they did something wrong. But under anti-retaliation statutes, if the landlord takes adverse action against you within 60 to 90 days of your protected complaint, the law assumes they are guilty of retaliation unless they can prove otherwise in court with hard evidence. Let's look at a realistic scenario. Say your heater breaks in October. You ask your landlord to fix it twice, they ignore you, so you file a formal report with the local housing code office. In late November, 6 weeks later, you receive a notice stating your lease won't be renewed at the end of the term, with no reason given. Because that non-renewal happened within that 60 to 90-day window, the court presumes it was retaliatory payback. Your landlord now has to produce hard evidence proving the non-renewal had absolutely nothing to do with your code complaint. If they can't prove it, that non-renewal gets thrown out in court, and in many jurisdictions, you can sue them for retaliatory statutory damages on top of keeping your home. Let's run through constructive eviction as well. because landlords often try to get clever without touching the locks. Constructive eviction happens when a landlord doesn't physically lock you out, but intentionally allows the living conditions to deteriorate so severely that no human could reasonably stay there. Leaving a broken main pipe gushing water for weeks, ignoring a caved-in ceiling, or letting a severe pest infestation go completely unmanaged. Under the law, if the unit becomes legally uninhabitable and the landlord neglects it despite written notice, it is treated with the exact same legal severity as an illegal lockout. You are granted the right to break the lease immediately, without penalty, relocate, and sue for relocation damages. At the end of the day, turning a nightmare landlord scenario into a full cash recovery doesn't require you to memorize complex legal codes or act aggressively. It comes down to one core habit: documentation. The second a lock doesn't turn, a utility vanishes, or an illegal notice gets posted on your door, pull out your phone. Take time-stamped photos and videos. Save every text message, email, and voicemail. Keep an organized folder of every single interaction with date stamps attached. That paper trail is the entire ballgame. You don't need to know exact statute numbers on minute 1. You just need the physical evidence to exist so that the moment you hand it over to a lawyer, a tenant union, or a small claims judge, your case is open and shut. If this was helpful, hit subscribe, because there's a lot more your landlord hopes you never find out.